everybody. It is 3 o'clock. I'd like to call the October 4th meeting of the Environmental Resources Committee to order. We will begin with item number 2, the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Moving on to item number 3, public comment, 15-minute limit. I have 5 individuals signed up to speak. Given the 15-minute limit, I will give each individual 3 minutes to speak. I will give a 30-second warning, the amount left that you have to address the group. Quick reminder that you will address the committee. Please do not look back to the crowd or anything. If it's public comment, your public comments to the committee and not anybody else. And we will begin with Bruce Grau, I believe. Yep, right up there. Thank you, Bruce. And then name and municipality. Name and municipality, please.
Bruce Grau, Wausau.
All right, go ahead, Bruce.
The time has come to decide how to proceed with gold mining in the reef. We expect you've done your due diligence to the people and natural resources of Marathon County by intensely researching this issue. You've found that mining for gold always causes pollution harmful to workers, wildlife, and residents. You've determined that it's very suspicious that GLM has applied now since the regulations have relaxed, despite their claim that their process creates no toxic effects. You've agreed that adding to the list, including 40% of all watershed headwaters contaminated by mining operations, is unsupportable. You've come to see that promised jobs don't materialize or last. Most likely, we will become the responsible party to clean up the inevitable toxic mess left behind, adding to the $35 billion bill of defunct gold mine cleanup nationally. Violation of native treaty rights and allowing pollution in areas where 25 to 35% of the population is poor smacks of actionable environmental injustice. There is no environmental El Dorado. Look beyond the lofty sales pitch down into the dirty facts. Vote yes to clean water, honest business, and the will of the people most impacted by this. Vote for the resolution presented to you today. Protect Marathon County and beyond. Thank you.
Thank you. Moving on, I have Ron James.
Ron James, Town of Evergreen. This Marathon County comprehensive plan that you all work so hard, first of all, it's good to be amongst friends and neighbors. This comprehensive plan that you worked so hard on mentions the word water 556 times. Water is mentioned more than any other valuable asset in the county. And why? Because you want to protect water. Every aspect of the resolution you're considering today supports the protection of Marathon County water. But your ability to protect water was diminished with the passing of Act 134. The resolution is about proclaiming your right to regain your ability to protect the water. The resolution calls for the repeal of Act 134 so that this local unit of government has the ultimate say-so when it comes to knowing what's right for Marathon County. Proclaiming your right to protect the water is the right thing to do. Approving the resolution aligns with your comprehensive plan by asserting your right to protect the water. Thanks, you guys.
Thank you. Next, I have Nancy Stencil.
Hello there, Nancy Stencil, Town of Rib Mountain. I would ask today that you please adopt this resolution, along with resolutions from a multitude of Indian nations and Wisconsin environmental organizations, which I've got extra copies here as well if anybody would like. These copies are from the Ho-Chunk Nation, the Menominee Nation, Dr. Paula Mohan, who is an environmental scientist, the Great Lakes Intertribal Council, the Oneida Clean Water Action, and the Wisconsin Resources Protection Council. And I'd like you to adopt this because I really feel that it'll bring back your much-needed local control. The control that you so desperately need to carry out the wonderful work that you have done in creating your comprehensive plan. This is the first and foremost essential is clean water in Marathon County. Thank you. And I would really like to see these documents all scanned in to the records. There are a total of 8 documents. And I also, with that, have over 500 signatures on a petition. And we do have somebody else who was not able to be here today who also will have petitions for you. Thank you.
Thank you. Next, I have Dan Barth.
I believe he's on WebEx.
Go ahead, Dan. Oh, did I unmute? Sorry about that.
On the 18th of this month, we will celebrate the 50th anniversary of the Clean Water
Dan,
Act.
I'm gonna pause you just for a second. I'll give you your time back, but
Okay.
name and place the municipality, okay?
Okay, I tried, but I kept getting muted. I'm Dan Barth, Town of Knowlton.
Okay, I'll start your time when you
Marathon
start
County.
speaking.
Okay. On the 18th of this month, we will celebrate the 50th anniversary of the Clean Water Act. In 1972, our nation's waters were so polluted by industrial waste that the legislators of both parties in both the House and Senate overrode President Nixon's veto of the bill by wide margins in less than 24 hours. Thanks to its enforcement, our waters are much cleaner today, but they remain under constant threat, as the residents of Wausau and the operators of water treatment plants across the country know all too well. We, the residents of Marathon County, look to the members of this Environmental Resources Committee to do all that they can to protect the safety of our water and the health of our environment. Water and environment that are now under serious threat from plans to drill and develop a toxic sulfide gold mine not far to our east. We know you did not come to this committee to be told by the state that you have no power to protect your own county and your own constituents. That is why we ask you to approve and pass on to the entire county board the petition before you today, calling on our state leaders to return to you the power you once had to do so. No one can take the power of your voice away. I call on you to use it. I was the person who was bringing the rest of the petitions. I apologize for not being there. It was unavoidable. Be happy to bring them in at any time you want me to bring them. Thank you.
Thank you. And next I have Kathy Conte Barth.
Kathy Conley Barth.
Here, have her start again. Kathy, you want to start again?
Should I go ahead?
Yeah, go ahead.
Okay. I just wanted to briefly say that there are actions
Kathy,
that we
similar
can
to
take that are for
Dan, I'm going to have you say your name and your municipality, please, and I'll start your time afterwards.
Okay. Yes, I did that twice, but it's Kathy Conley Barth, Town of Knowlton.
Thank you. Go ahead.
Thank you. I just wanted to briefly say that there we can the most cannot be undone. One of the This is why the Prove It First law was passed by such wide margins in both houses. What can we do to protect the waters that we have for fishing and recreation and drinking? These waters will flow through Weston and into the Clare River and into the the Wisconsin River. We can't afford to take the chances that these companies are saying that we need to take. Thank you.
Thank you, and thank you to those joining us over WebEx with dealing with the technology difficulties. Appreciate it. Okay, moving on to item number 4. We have approval of the August 30th, 2022 committee minutes. They were in your packets. It was the pleasure of the committee. Motion by Supervisor Drabeck, second by Supervisor Unger. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Thank you. Moving on to item 5, operational functions required by statute, ordinance, or resolution. We have 5A, public hearings, review, possible actions, and possible recommendations to the county board for its consideration. County zoning changes. We would ask that everybody here please mute your electronic devices, and anybody that's joining us over WebEx, please mute yourself if you are not testifying for the committee. The Marathon County ERC is now meeting a public hearing on the location plan specifications, the purpose of the following projects. 5A1, Don Sebastian, Farmland Preservation to Rural Residential, Town of Mcmillan. 5A2, Larry and Patricia Lang, General Agriculture to Rural Residential, Town of Spencer. And 5A3, Daniel and Jennifer Schreiber, General Agriculture to Rural Residential, Lot 1, and General Agriculture to Rural Estate, Lot 2, Town of Holton. Very quickly, I'll go through the members of the committee. Myself, Jake Langenhan, the committee chair, Al Drabeck, the vice chair, Supervisor Oberbeck, Supervisor Ritter, Supervisor Vensky, Supervisor Shafinsky, Supervisor Unger, and Marilyn Bend, our Wisconsin Towns and Villages Association rep. Also present are Lori Miskimans, our Conservation Planning and Zoning Director. Kirsty Heidenreich might be here somewhere joining us. County Conservationist, Shad Harvey, our Land Resource Manager, Nicole Delaney, our Administrative Coordinator, Garrett Poggle, our Land Use Technician, and Teal Fikesen, Land Use Specialist. The establishment of the ERC is required by law for purposes of administration of county ordinances and land conservation programs. The committee must follow state laws and local ordinances as written. This committee cannot change or ignore any part of the ordinances or state laws, must apply the laws as written. The purpose of this committee is to hear and decide on proposed ordinances and ordinance revisions, rezoning petitions, and provide direction on land conservation and planning programs. The ERC will give a full and fair hearing to any person applying for a rezone petition. A taped recording is being made of the meeting, which will assist with preparation of written hearing minutes. The committee is interested in hearing all pertinent comments and questions. Each hearing will be opened by reading the public notice and allowing staff to present a staff report, including evidence from any on-site inspection. The applicant and anyone wishing to testify will be sworn in and allowed to give testimony. Witnesses will be called in order of first in favor, second opposed, and then third as interested may appear. The committee may ask questions of the zoning staff and applicant. It is necessary that we set a reasonable time limit on individual statements on the overall length of the hearing. To promote orderly discussion, anyone wishing to present oral testimony or ask questions relating to the hearing should state your name and present your testimony or questions so it becomes part of the official record. We request you avoid repetition. Once the committee has all the necessary facts, the chairman will close the hearing, allowing no further testimony, and the committee will deliberate and decide in front of the public whether the applicant has met the standards of the ordinance. No additional testimony from the public is allowed during the deliberation. However, the committee may question staff for purposes of clarification. After a decision is made, the committee will proceed to the next hearing. Many of the decisions made by the committee are a recommendation to the Marathon County Board of Supervisors, who will take up the matter at a future county board meeting. Please contact staff for more information regarding this county board process. We will now begin by hearing the application of 5A1, Don Sebastian, Farmland Preservation to Rural Residential, Town of Mcmillan. And we will begin with our staff report. And I believe we have Garrett for that today. Garrett, do you swear to tell the truth, the whole truth, and nothing but the truth? I do. Okay, go ahead.
Today we have Don Sebastian, Petition to Rezone Land Staff Report, October 4th, 2022, Environmental Resources Committee. The petitioner is Tim Vreeland, 6103 Dawn Street, Weston, Wisconsin, 54476. The property owners are Don Sebastian, 114042 East McMillan Street, Marshfield, Wisconsin, 54449. The area to be proposed to be rezoned is in the town of McMillan on the corner of State Highway 97 and Galvin Avenue. The petition of Tim Vreeland on behalf of Don Sebastian to amend the Marathon County zoning ordinance to rezone lands from farmland preservation to rural residential as described as part of the northeast quarter of Section 33, Township 26 North, Range 3 East, Town of Mcmillan. The area proposed to be rezoned is described as Lot 1 and 2 of the preliminary CSM, parent parcel 056 2603 331 0999. Public hearings and meetings. The Town of Mcmillan Town Board met on September 12, 2022. Marathon County Environmental Resources Committee meeting today, October 4th, 2022 at 3 p.m. A legal advertisement was published in the Wausau Daily Herald. Notice of the zoning change request was also sent by regular mail to adjacent property owners within 300 feet of the subject property. The existing zoning district is farmland preservation. The existing land use map, comprehensive plan 2021 for the town of Mcmillan. The area proposed to be rezoned is shown as woodlands, agriculture, and residential in the town's comprehensive plan existing land use map from 2021. And those adjacent land uses are comprised of woodlands, agriculture, residential, and some commercial sites. The proposed zoning district is rural residential. The future land use map for Town of Mcmillan 2021 plan. The area proposed to be rezoned is shown as commercial in the town's comprehensive future land use plan from 2021. Adjacent land uses are comprised of commercial, residential, and agriculture. The Town of Mcmillan in their resolution did state that the area to be rezoned was mislabeled during their comprehensive update in 2021 and was meant to be in residential use in nature. The Town of Mcmillan participates in farmland preservation zoning, and 17.7 acres of farmland preservation zoning area will be consumed by the rezone. This is the aerial map of the site to be rezoned. The certified survey map showing lots 1 and 2. Town recommendation on September 12th, 2022, the Town of Mcmillan Town Board recommended approval to Marathon County's Environmental Resources Committee. Staff comments regarding ERC conclusions of law. Number 1, the rezoning is substantially consistent with the following plans. Note how the proposed relates to the future land use plan and the vision, goals, objectives, and policies of the plan. Marathon County Comprehensive Plan, Town Comprehensive Plan, and Marathon County Farmland Preservation Plan. The Marathon County Comprehensive Plan relies on the Town Comprehensive Plan regarding specific land uses and zoning districts for individual parcels. The area proposed to be rezoned is shown to be designated as commercial in the town's future land use map. However, the Town of Mcmillan has stated it is meant to be residential. CPZ staff rely on the towns to make these recommendations, given the town board members and residents know their town and the true purpose and intent of the plan. The area in question is designated as a farmland preservation area. The Town of Mcmillan participates in farmland preservation zoning. As indicated by the town's resolution recommendation, it appears the rezone is consistent with the purpose and intent of the comprehensive plan. Number 2, the location of the proposed development minimizes the amount of agricultural land converted and will not substantially impair or limit current or future agricultural use of other protected farmland. No farmland will be consumed by this rezone and is not currently farmed. The applicant has demonstrated that A, there is a need for the proposed development, B, the adequate public facilities are present or will be provided, no impacts on roads, water, sewage, drainage, schools, emergency services, etc. And C, providing public facilities will not be an unreasonable burden to the local government. The need for is for a proposed land division. All necessary public facilities are anticipated to be provided, if not already provided, given any proposed development would rely of private systems such as a private well and sanitary system if applicable. No anticipated burden on local government. All applicable building, construction, and use standards will be applied during the zoning and building permit review process. The rezoning will not cause unreasonable air and water pollution, soil erosion, or adverse effects on rare or irreplaceable natural areas. All federal, state, and local permits and approvals are required for any applicable development on site. Additionally, the proposed rezone will likely not result in any unreasonable air and water pollution, as all pertinent regulations apply and will need to be adhered to. Any disturbance greater than 1 acre would need a DNR stormwater management permit. The town has approved the proposed rezone of the property. The Town of Mcmillan Town Board has recommended approval of this rezone petition. All concerns from other agencies on the proposed rezone have been addressed, DNR, Highway, DOT. What are the concerns? The county is not made aware of any concerns from other agencies. CPZ staff recommendation, the rezone meets all the zoning district standards as it relates to size, frontage, access, and dimension. The rezone also appears to be consistent with the purpose and intent of the town's comprehensive plan as indicated by the town's resolution. Based on the information provided above, findings of fact, conclusions of law, and the town's recommendation, it appears the rezone request meets all the rezone criteria and standards for rezoning. Therefore, CPZ staff recommend that the Environmental Resources Committee recommend approval to the Marathon County Board of Supervisors.
Thank you, Garrett. Any questions for staff? Garrett, I think this was mentioned somewhere, maybe it was on the application that the applicant submitted, but it's in Farmland Pres, but there's no farmland in that, on that area, right?
Correct. None of the current parcel is being farmed.
Okay. Okay, thank you. Any questions? Nope. All right, thank you, Garrett. Moving on, I'd ask that anybody wishing to speak in favor of the proposed rezone, please come forward at this time and address the mic or unmute yourself over WebEx. Is Tim Vreeland on the call, Lori? Okay.
This is Dustin Vreeland, just here to answer any questions.
Dustin, it'd probably be best to swear you in case there are any questions. So do you tell the truth, the whole truth, and nothing but the truth? All right.
I do.
Go ahead if you have anything to offer for testimony.
I'm just here to answer any questions if you guys have any regarding the survey.
Okay. Thank you, Dustin. Any questions for Dustin? All right. We got none, Dustin. Thank you.
Thank you.
All right. I'll call one more time. Anybody wishing to speak in favor of the proposed request, item 5A1, please identify yourself at this time. Last call. Seeing and hearing none. Anybody wishing to speak against the proposed request, please identify yourself at this time. Last call. Anybody wishing to speak against the proposed rezone? Seeing and hearing none. Anybody wishing to speak as interested, please identify yourself at this time. Last call. Anybody wishing to speak as interested under item 5A1? All right. Seeing and hearing none. If no one else wishes to testify for this application, I am now declaring the public hearing on Don Sebastian, Farmland Pres to Rural Residential, Town of Mcmillan, closed. The committee will now deliberate on the application, apply the standards of the zoning ordinance. What was the pleasure of the committee? Supervisor Seefeld.
Make a motion for the petition of Tim Breland on behalf of Don Sebastian to amend the Marathon County zoning ordinance to rezone land from farm preservation to rural residential as described in the town of Mcmillan, and to forward the conclusions of law, or to pass the conclusions of law and to forward it to the county board.
Motion was made, second by Supervisor Sherfinsky. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Supervisor Seefeld, I'm sorry I missed you during introductions. I didn't think you were going to be here today. All right, good to have you. All right, moving on to 5A2, Larry and Patricia Lang, General Agriculture to Rural Residential, Town of Spencer, and we're back with Garrett.
Okay, this is the petition for Daniel and Jennifer. Oh, why do I have this one? One second here, Jacob. All right, this is a petition of Larry and Patricia Lang, petition to rezone land, staff report, October 4th, 2022, Environmental Resources Committee. The petitioner is Larry and Patricia Lang. They reside at 104-094 26th Road, Marshfield, Wisconsin, 54449. The property owner is the same as the petitioner. Location of the rezone, the area proposed to be rezoned is just east of the intersection of Beebe Road and 26th Road. The petition by Larry and Patricia Lang to amend the Marathon County zoning ordinance to rezone lands from general agriculture to rural residential as described as part of the southeast quarter of the southwest quarter of Section 22, Township 26 North, Range 2 East, Town of Spencer. The area proposed to be rezoned is as described as Lot 1 and 2 of the preliminary CSM. Parent parcel number 074-2602-223-0984. The Town of Spencer Town Board met on September 13th, 2022. The Marathon County Environmental Resources Committee meeting today, October 4th, 2022 at 3 p.m. A legal advertisement was published in the Wausau Daily Herald. Notice of the zoning change request was also sent by regular mail to adjacent property owners within 300 feet of the subject property. The existing zoning district is general agriculture. The existing land use map for the town of Spencer from their comprehensive plan in 2016. The area proposed to be rezoned is shown as woodlands and agriculture in the town's comprehensive existing land use map. The adjacent land uses are comprised of woodlands, residential, commercial, outdoor recreation, and agriculture. The proposed district is rural residential. Town of Spencer's comprehensive future land use map. The area shown to be rezoned is shown as agriculture in the town's comprehensive plan for 2000. The adjacent land uses are comprised of commercial, residential, and agriculture. The town of Spencer does not participate in farmland preservation zoning. Aerial photo showing the parcel to be rezoned. The two lots that are going to be rezoned, Lot 1 and 2. The town recommendation on September 13th, 2022, the Town of Spencer's Town Board recommended approval to Marathon County's Environmental Resources Committee. Staff comments regarding ERC conclusions of law. The rezoning is substantially consistent with the following plans. Note how the proposed relates to the future land use plan and the vision, goals, objective, and policies of the plan. Marathon County's comprehensive plan, the town comprehensive plan, and Marathon County Farmland Preservation Plan. The Marathon County Comprehensive Plan relies on the town's comprehensive plan regarding specific land uses and zoning districts for individual parcels. The area proposed to be rezoned is designated as agriculture in the town's future land use map. CPZ staff rely on the towns to make these recommendations, giving the town board members and residents know their town and the true purpose and intent of the plan. The area in question was not designated as a farmland preservation area. The town of Spencer does not participate in farmland preservation zoning. As indicated by the town's future land use map and resolution recommendation, it appears the rezone is consistent with the purpose and intent of the comprehensive plan. The location of the proposed development minimizes the amount of agriculture land converted and will not substantially impair or limit current or future agricultural use of other protected farmland. The land is currently used for horse pasture and hay, and no row crop land will be consumed. The applicant has demonstrated that there is a need for the proposed development. Adequate public facilities are present or will be provided, no impacts on roads, water, sewage, drainage, schools, and emergency services. And providing public facilities will not be an unreasonable burden to the local government. The need is for a proposed land division. All necessary public facilities are anticipated to be provided, if not already provided, given any proposed development would rely on private systems such as a private well and sanitary system if applicable. No anticipated burden on local government. All applicable building, construction, and use standards will be applied during the zoning and building permit review process. The rezoning will not cause unreasonable air and water pollution, soil erosion, or adverse effects on rare or irreplaceable natural areas. All federal, state, and local permits and approvals are required for any applicable development on site. Additionally, the proposed rezone will likely not result in any unreasonable air and water pollution, as all pertinent regulations apply and will need to be adhered to. Any disturbance greater than 1 acre would need a DNR stormwater management permit. The town has approved the proposed rezone of the property. The Town of Spencer Town Board has recommended approval of this rezone petition. All concerns from other agencies on the proposed rezone have been addressed. DNR, Highway, and DOT. What are the concerns? The county was not made aware of any concerns from other agencies. The rezone meets all of the zoning district standards as it relates to size, frontage, access, and dimension. The rezone also appears to be consistent with the purpose and intent of the town's comprehensive plan and as indicated by the town resolution. Based on the information provided above, findings of fact, conclusions of law, and the town's recommendation, it appears the rezone request meets all the rezone criteria and standards for rezoning. Therefore, CPZ staff recommended that the Environmental Resources Committee recommend approval to the Marathon County Board of Supervisors.
Okay, any questions for Garrett? Seeing and hearing none, thank you, Garrett. Moving on, I'd ask that anybody wishing to speak in favor of the proposed request, and again, we're under 5A2, Larry and Patricia Lang, General Ag to Rural Residential Town of Spencer. Please either unmute yourself over WebEx or approach the microphone at this time. I'll call again. Anybody wishing to speak in favor of the proposed rezone request, 5A2, please unmute yourself or come forward and address the mic at this time. Last call.
You have Mr. Lang on the line for questions, I believe. So.
Okay. Larry, are you joining us over WebEx? We'll give him a couple seconds. Is he unmuted, Lori? Yeah. Okay. Well, Larry, I'm going to call again.
Yeah.
Oh, there you are. Okay. Larry, I'm going to swear you in very quick in case the committee has any questions. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead.
I have no comment, I guess, as far as just trying to get the approval through.
Sure. Are there any questions for the committee? All right, seeing and hearing none. Thank you, Larry.
You bet.
All right, moving on to anybody else wishing to speak in favor of the proposed rezone request. Last call. All right. Anybody wishing to speak against the proposed rezone request, please either unmute yourself at this time or approach the microphone. Last call. Anybody wishing to speak against the proposed rezone request, please unmute yourself or approach the microphone at this time. Seeing and hearing none. Anybody wishing to speak as interested for the proposed rezone, 5A2, please identify yourself at this time. Last call. Anybody wishing to speak as interested. If no one else wishes to testify for this application, I am now declaring the public hearing on Larry and Patricia Lang, General Agriculture to Rural Residential Town of Spencer, now closed. The committee will now deliberate on the application and apply the standards of the zoning ordinance. What is the pleasure of the committee? Supervisor Drabeck.
Thank you, Mr. Chair. I'd like to make a motion to approve the rezone of Larry and Patricia Lang from general agriculture to rural residential based on the finding facts and conclusions of law.
All right, motion's been made. Is there a second? Second by Supervisor Ritter. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Moving on to the third rezone, third and final. We have 5A2, Daniel and Jennifer Schreiber, General Agriculture to Rural Residential, Lot 1, and General Agriculture to Rural Estate, Lot 2, Town of Holton. Go ahead, Garrett.
All right, this is the petition of Daniel and Jennifer Schreiber, petition to rezone land, staff report, October 4th, 2022, with the Environmental Resources Committee. The petitioner is Jason Flieger at 163957 Owl Ridge Road, Wausau, Wisconsin, 54403. The property owners are Daniel and Jennifer Schreiber at 106993 Würzburg Road, Abbotsford, Wisconsin, 54405. The area proposed to be rezoned is in the town of Holton on Würzburg Avenue, directly west of the intersection of Würzburg Avenue and County Road F. The petition of Jason Flieger on behalf of Daniel and Jennifer Schreiber to amend the Marathon County zoning ordinance to rezone lands from general agriculture to rural residential, Lot 1, and general agriculture to rural estate, Lot 2, as described as all of Lot 1 of CSM number 15798, located in the northwest quarter of the northeast quarter of Section 35, Township 29 North, Range 2 East, Town of Holton. The area to be rezoned is described as Lot 1 and 2 of the preliminary CSM, parent parcel 042-2902-351-0986. The Town of Holton Town Board met August 10th, 2022. Marathon County Environmental Resources Committee meeting October 4th, 2022 at 3 p.m. A legal advertisement was published in the Wausau Daily Herald. Notice of the zoning change request was also sent by regular mail to adjacent property owners within 300 feet of the subject property. The existing zoning district is general agriculture. The existing land use map for the town of Holton from the comprehensive plan in 2006. The area proposed to be rezoned is shown as other agriculture and woodlands in the town's comprehensive plan existing land use map. Adjacent land uses are comprised of woodlands, single-family residential, cropland, and other agriculture. The proposed zoning districts, Lot 1 is proposed to be rural residential, and Lot 2 is proposed to be rural estate. The town comprehensive future land use plan from 2006, the area proposed to be rezoned is shown as woodlands, single-family residential, cropland, and other agriculture in the town's comprehensive future land use map. Adjacent land uses are comprised of woodlands, single-family residential, cropland, and other agriculture. The town of Holton does not participate in farmland preservation zoning. Aerial photo of the parcel in question with the certified survey map. The town recommendation on August 10th, 2022, the town of Holton's town board recommended approval to Marathon County's Environmental Resources Committee. Staff comments regarding ERC conclusions of law. The rezoning is substantially consistent with the following plans. Note how the proposed relates to the future land use plan and the vision, goals, objectives, and policies of the plan. Marathon County's comprehensive plan, town comprehensive plan, and Marathon County farmland preservation plan. The Marathon County comprehensive plan relies on the town comprehensive plan regarding specific land uses and zoning district for individual parcels. The area proposed to be rezoned is shown to be designated as agriculture and woodlands in the town's future land use map. CPZ staff rely on the towns to make these recommendations, given the town board members and residents know their town and the true purpose and intent of the plan. The area in question was not designated as a farmland preservation area. The town of Holton does not participate in farmland preservation zoning. As indicated by the town's future land use map and resolution recommendation, it appears the rezone is consistent with the purpose and intent of the comprehensive plan. The location of the proposed development minimizes the amount of agricultural land converted and will not substantially impair or limit current or future agricultural use of other protected farmland. No farmland will be consumed by the rezone. The applicant has demonstrated that there is a need for the proposed development. Adequate public facilities are present or will be provided. Note impacts on roads, water, sewage, drainage, schools, emergency services, etc. And providing public facilities will not be an unreasonable burden to the local government. The need is for a proposed land division. All necessary public facilities are anticipated to be provided, if not already provided, given any proposed development would rely on private systems such as a private well and sanitary system, if applicable. No anticipated burden on local government. All applicable building, construction, and use standards will be applied during the zoning and building permit review process. The rezoning will not cause unreasonable air and water pollution, soil erosion, or adverse effects on rare or irreplaceable natural areas. All federal and local permits and approvals are required for any applicable development on site. Additionally, the proposed rezone will likely not result in any unreasonable air and water pollution, as all pertinent regulations apply and will need to be adhered to. Any disturbance greater than 1 acre would need a DNR stormwater management permit. The town has approved the proposed rezone of the property. The town of Holton Town Board has recommended approval of the rezone petition. All concerns from other agencies on the proposed rezone have been addressed, DNR, Highway, DOT. What are the concerns? The county was not made aware of any concerns from other agencies. The rezone meets all of the district standards as it relates to size, frontage, access, and dimension. The rezone also appears to be consistent with the purpose and intent of the town's comprehensive plan and as indicated by the town resolution. Based on the information provided above, findings of fact, conclusions of law, and the town's recommendation, it appears the rezone request meets all the rezone criteria and standards for rezoning. Therefore, CPZ staff recommend that the Environmental Resources Committee recommend approval to the Marathon County Board of Supervisors.
Thank you, Garrett. Any questions for staff from the committee? Thank you, Garrett. All right, moving on to testimony from the public. Anybody wishing to speak in favor of the proposed rezone requests? If you're joining us over WebEx, please unmute yourself at this time or approach the microphone at this time if you're in person. Anybody wishing to speak in favor of the proposed rezone request, please identify yourself at this time. This is 5A3, Daniel and Jennifer Schaefer. Last call, anybody wishing to speak in favor of the proposed? Oh, I'm sorry. Sorry. It's tough when you gotta look at WebEx and then over here too. Okay, name please.
Dan Schreiber, Town of Holton.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead, Dan.
I'm just here. If anybody has any questions for me, I'm here for that. We're just doing the rezone for our daughter to build a house by us and her grandma and her uncle all together.
Okay,
That's all I have. Anyone have questions? I'm here.
sure. Okay, any questions for Dan at this time? All right, thank you.
You're welcome. Thank you.
All right, anybody else wishing to speak in favor of the proposed rezone request, please identify yourself at this time. Last call, anybody wishing to speak in favor of the proposed rezone request? Seeing and hearing none. Anybody wishing to speak against the proposed rezone request, 5A3, please identify yourself at this time. Last call, anybody wishing to speak against the proposed rezone request, 5A3? Seeing and hearing none. Anybody wishing to speak as interested, the proposed rezone request, 5A3, at this time, please unmute yourself if over WebEx or approach the mic. Seeing and hearing none. Anybody wishing, or last call, anybody wishing to speak is interested? All right, seeing and hearing none. If no one else wishes to testify for this application, I'm now declaring the public hearing on Daniel and Jennifer Schreiber, General Agriculture to Rural Residential, Lot 1, and General Agriculture to Rural Estate, Lot 2, Town of Holton, now closed. The committee will now deliberate on the application and apply the standards of the zoning ordinance. What is the pleasure of the committee? Supervisor Seefeld.
Thank you, Mr. Chair. I'll make a motion for the petition of Jason Flieger on behalf of Daniel and Jennifer Schreiber to amend the Marathon County zoning ordinance to rezone land from general agricultural to rural residential in the township of Holton, and to pass the conclusions of law and to forward it to the county board.
Motion is made. Is there a second? Second by Supervisor Sherfinsky. Any further discussion? Supervisor Drayback.
Thank you. I'm not trying to complain, but it was a lot 2 as well. There's a lot 1 and a lot 2. Am I correct? That has to be in the motion.
Yeah, would you add that to your motion? Okay.
Lot 1 and
2. Okay. All right.
Lot 1 and 2.
Okay. Thank you. And I'm assuming the second remains the same, Supervisor Sherfinsky? Okay. Thank you. All right. Any further discussion? Thank you, Supervisor Drayback. Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Thank you, everyone. Due to the closed session that we have later in the agenda, in the interest of record keeping, we're going to be passing out these signature forms now, so that staff can be on their way when we get to the closed session. So, starting with me. Very quickly. All right, there you go. Do you need a, pass it down. All right, those 3 are for you, Shad. There you go. All right. Thank you, everybody. Moving on to 5B, review and possible recommendations to the county board for its consideration. Town zoning changes pursuant to Wisconsin statute 60.62 sub 3. We have none. 5C, review and possible recommendations to the county board for its consideration. None. And then 5D, review and possible action. We have none. Moving on to item 6, educational presentations, outcome monitoring reports, and committee discussion. A, department updates, conservation planning and zoning, park rec and forestry, solid waste. And we'll begin with 6A1, funding for the groundwater plan in 2023. Start with Lori?
Yeah, I'll just give a brief update. This was included in the tentative list adopted by County Board for the Capital Improvement Program last week, but with the guidance that was given by County Board, it is on the list, but it has not been identified for funding in 2023 at this time. So I'm coming back to the ERC to give you that update and just start a discussion about alternative strategies, because we do believe that now would be the time to get the plan underway, especially as it relates to getting well testing done to get that data gap filled for what we need for the plan. So the proposal that went into the SIP request did include funding for getting wells tested as well. And part of the reason we did that was because not only just to get better data so we could do a comprehensive plan update, but because there is funding available from the state right now to help with well reconstruction. So if citizens did identify that there was a problem with their well, there is some limited time funding available through the ARPA program so that they could get that well repaired. So We are starting to consider alternative strategies, like possibly taking it back before the board again for ARPA, contingency ideas for taking it through SIP, but I wanted to bring it to ERC to start that discussion on how we should approach this going forward if our goal is still to get the groundwater plan underway in 2023.
I think I'll start the discussion. In regards to the project, what was the total ask for CIP?
The total ask was estimated at $300,000. About half of that was identified for well testing. So we were targeting 1,000 well tests throughout the county, and that was based on consultation with some groundwater lab technicians.
Okay. Is it possible to scale that project down to a point where you still accomplish the objectives of the project?
So I think some strategies we have talked about are, so the original plan did include full funding for those 1,000 well tests, so we could look at only providing partial funding, and the landowner would bring some of that funding to the request. Our goal is to get as many samples as possible, and we believe the more the county can provide funding for those samples, the higher participation rate and the more data we would get for the plan. So,
Go ahead, Marilyn.
Katrina Shanklin from down in Portage County has done something where that they're doing the testing of wells down there for the nitrates, and that was a state project. Is Marathon County able to tap into any of that that she has done with her law that she has?
So I did review the application information that came out over the weekend for this. This is the same program. It does look like water testing of wells is eligible as part of that as well. So that is another, we could start by encouraging owners within the county to go that route and see if they could secure the funding both for the testing, and then if they do find a problem with their well, the reconstruction as well. So
I'll do your follow-up. Go ahead and, oh, okay.
there are some, sorry, I forgot to add, there are some income restrictions for that program. I don't know what they are off the top of my head. So.
Okay, Supervisor Stravinsky, and then Marilyn will have a follow-up.
Thank you, Chairman. My question is, how did you determine the number of wells to be tested, and is there any room that we could scale that back and still get good data? I look at where we're at, and I think we need to, do what we can to maybe pull our expectations back a bit in line with where we are.
Yeah, so when we talked to the UW-Stevens Point Groundwater Lab and explained sort of they're familiar with our county, they're familiar with how much data we have here. That was their recommendation, was to target 1,000. Absolutely, I think we could look at a smaller sample. The more samples we can get, obviously, the more comprehensive the plan can be. So.
Okay, Marilyn?
I think there they said that they would pay for, it had to be a private well, and they would pay for up to $16,000 for it, and the income limit, I think, was over $100,000, because otherwise, before, people weren't able to take advantage of that. Thank you.
Again, I'm not up to speed yet on the total income parameters. I know it will be an application process where they will have to go through the state to get the testing done, and then I believe for the reconstruction costs. So, yeah.
All right, Supervisor Draybeck.
Thank you, Mr. Chair. I know I've asked this question before, but the dairy farmers, they have to have their well tested every year. I believe the grade A dairy farmers. Is there any way that we can get information from that would help for different areas? So my understanding is the only data we have access to is the stuff that is tested through our health department. So so we do have some data, but it is not as much as we don't have access to everything. So. But I can double check that for you. So I appreciate that. Thank you.
That's an interesting point, because wouldn't DATCAP have that information? Right? Yeah. No, excellent point. Okay, I have a question for our administrator. When is the next round of ARPA funding, that application process, when is that due next?
The application period for the second round of this year just closed on the 1st.
Approximately how much money is left or is unallocated?
I can, if you give me several minutes, I can look into that, but off the top of my head, you set aside approximately $10 million for highway projects. You had it previously allocated $5 million for existing projects. There was, for broadband, another $4 million allocated. So I think by the time you're about that, certainly within that $5 million mark, but I can get you a more definite dollar amount. Again, it's important to note that a fair amount of those fees were set aside, but the highway projects, we have not been awarded all of those projects, and I think it's unlikely we would get all of them. But I can work to get you a more refined number.
In the meantime, is it accurate to say that with the departments of, conservation planning, zoning, solid waste, park and rec, and forestry, has there been any ARPA funding allocated to any initiatives under those departments?
There has been funding that was, at least on my spreadsheet, I recall setting aside for project applications that were made, and then the HR Finance Committee indicated that those projects would go through the budget process for consideration, and one of them was this project. But off the top of my head, I don't know. Let me pull up the spreadsheet, and I'll make sure I have better information for you. But
Okay.
I'll get you a refined number on the total projects outstanding, and I can tell you if any of those were already allocated to any of the departments under the purview of this committee.
The point that I'm trying to sort of get at is that if it wasn't funded through KIP, or highly unlikely that it's going to get funded through KIP, and I think that in regards to the remaining funds, which sounds like there is funds that are unallocated, it's a small ask for, well, not to say that 6 figures is small, but I think that it's fair that conservation planning and zoning could ask for something and have a competitive application, considering that, nothing's been allocated thus far, it sounds like to me. But any other thoughts, questions from the committee?
Mr. Chairman, question for you on the ARPA funds. Maybe I'm misunderstanding what those were intended for, but I thought those were intended as a COVID relief fund. Or am I misunderstanding the original intention?
All right. Well, here's the interesting thing about, and if staff want to correct me on anything I'm about to say, please, but with the COVID, or with the ARPA funds, there's 4 allowable use categories. One of them is called replacing lost public sector revenue. Essentially how that works is that if a unit of local government that receives ARPA funds can demonstrate that they experienced the loss due to the pandemic, they can take a corresponding amount of ARPA funds and use them to provide government services. There's 2 ways to determine loss. You can either use a formula provided by the Treasury, or you can claim a standard allowance of up to $10 million. I'm guessing the county used the formula because we exceeded we have more than that 10 million. So the way that works is that, well, what is a government service? A government service is any service traditionally provided by a government unless the Treasury has stated otherwise. So examples that they include in the guidance would be public health and safety, fire service, and road maintenance, which you can kind of see some of that thus far, that the ARPA funds have likely been justified through some of the projects that the administrator just listed under revenue loss. But you notice how flexible that is. It's a service traditionally provided by a government unless the Treasury stated otherwise. There's things like debt service that you can't do it, but it's very flexible. So there's probably a good shot that it would qualify under revenue loss. So I don't know if that answers your question.
Well, it does. Basically, there's the definition and the rules are written in such a way as that you could drive a 18-wheel truck through it. There's not much in the way of restriction.
That allowable use category is very flexible. The other 3, there's providing premium pay to essential workers performing eligible workers performing essential work, making investments in water, sewer, and broadband infrastructure, and responding to the public health emergency and its negative economic impacts. So like that one's more related to COVID, definitely, but lost public sector revenue, it's related in that they're looking at the revenue that was lost due to COVID, but you don't have to go back and justify how each penny was lost due to COVID. It's just the method that was used, which it sounds like we used the formula. So.
Right. No, I understand that.
Okay.
I think the other thing that we do need we should circle back and understand clearly is the idea that there might be data that is available and gathered based on dairy farming within the county.
Mm-hmm.
And I think that's something that we really, to be good stewards of any money, whether it's our taxpayer money or ARPA money, we should understand how much of that data is available first before we go out and, do things twice.
Yeah. No, I think to your point and Supervisor Drabeck's point, understanding the level of data that we have from the ag producers is certainly beneficial. The only thing I might add, and I guess staff could clarify, this was directed at residential wells, correct?
Correct.
Okay. So that's a limitation that we would have off of the stuff that DATCAP would regulate. So, my overall approach is that, or at least my current perspective is that if it's a relatively small ask for the remaining funds, and on top of that, this department has not been awarded a project as of yet, I believe that staff should pursue a scaled-down project using the ARPA funds to potentially fund this project in the future. Committee's thoughts? Supervisor Overbeck.
Thank you. I think one of the important things with the tests, though, are the consistency of what we're looking for. So we can get all the data so we know. I mean, one of the questions was PFAS and different things that we're looking for within that groundwater. So I think it'd be very important to keep the tests on a consistent basis as far as the data that's collected.
Thank you. Somebody else had their hand up. No? Any other comments, questions? Supervisor Drabeck.
I would just like to say, I understood the last time we talked about this that PFAS were not involved, that they wouldn't be not testing for PFAS.
So
Am I correct?
The test we budgeted for includes E. coli, nitrates, certain metals, and certain pesticides. There are only, I believe, 2 labs in the state that actually test for PFAS right now, and both of them would be very cost prohibitive for this effort. So we will not be testing for PFAS.
Thank you.
I hate to ask how much it would cost in order to include PFAS as well, but do you know?
I don't know off the top of my head. I would have to check with those 2 labs, and
Okay.
I don't know
But the intent of the project was to test for those 3 or 4 things that you just mentioned?
Yeah, so there's at least, I can pull up the list. It's we would at least get nitrates, E. coli's, certain heavy metals, and atrazine as well. So pesticides, yeah.
And I think that speaks to the county's role in a lot of these initiatives as far as what they can and can't do for certain things. But my direction, unless there's any objection from the committee, is that staff can pursue ARPA funding as a means to fund this project.
You mentioned a scaled-back project. So what do you have what is the thought in terms of a scaled-back project? Are we looking at testing 150, or I'm sorry, 750 wells, 500 wells?
Could we package it at levels? I mean, I assume in the application we could package it at different levels and see. I guess I'm looking, like, there's nothing that would restrict us from putting the application together.
Well,
like
on
that.
top of that, if we'd like to provide more input to the project, which I understand, when is the next, so this last one just ended, when is the next one again?
Next, looking on the website as we speak.
And I did just get, the estimate is $500 per test for PFAS, per well. So-
Thank you. Difference, yeah.
Here's doing the same thing. It's on the administration page of the website, and I'm having trouble accessing it right now.
Is that because you're not at your desk? Is
Yeah.
that what it is?
Yeah.
Okay.
Would be. I do have your updated information on the ARPA applications, if you want me to provide that to the committee just for context.
Please.
Again, I think it's important to know that these funds are allocated but not necessarily encumbered through expenditures already. But in terms of highway projects, there was $10,337,879 of ARPA funds that were allocated to a 4-year transportation plan enhancement project. $3,115,010 was allocated to North Central Healthcare for increased costs in connection with the remodel, and those, of course, would be spent. $2 million was allocated for the Regional Forensic Science Center project in the event additional funding was provided from the state of Wisconsin. So that adds up to slightly over $15 million for those projects. You also previously had approximately $4.1 million of projects that were previously approved in terms of broadband expansion, a PTO balance liability reduction, the Uniquely Wisconsin program, and leasing space within the community partner campus. Approximately $5 million of projects proposals were to be considered through the budget process. However, because of the direction from the HR Finance and Property Committee and full board that ARPA funds would not be spent unless they were specifically approved projects, those were not funded as alluded to by Director Ms. Kimmons, and those projects included 3 parks projects, updates at the Big O Plain, Dells of the Eau Claire, and 9 Mile, as well as some public safety projects within the Sheriff's Office, the District Attorney's Office, and the library. So those projects were not funded through the budget process. So you're in that area where, based on the allocated funds, you have in excess of 20 million allocated. However, perhaps not all of those projects from the Highway Department are going to be needed to be funded. If the Regional Forensic Science Center is not, does not receive additional funding from the state of Wisconsin, those $2 million could be reallocated. I will say, and my spreadsheet here that I'm operating off of hasn't been updated with the submissions for the second phase, but you have received, at the time that I put this spreadsheet together, just shy of $36 million of project requests, and you have received several more in the interim, so you have received far in excess of the 26.3 million that is available. With respect to the question about staff putting together a plan, I think we certainly can do that.
Go ahead.
And we can talk about what, again, as I understand that the desire is to have us get access to data. So as Supervisor Sherfinsky said, I think it does behoove us to understand what data is already available to us, particularly as it relates to residential wells. The announcement by the state of Wisconsin about the funds available for not only testing, but then also well enhancements in the event that a problem is identified, I think is a good opportunity. Landowners should be, we can provide education that's available, and if they're going to do that on their own, perhaps the way to induce them to do it and to give them the data is to give us the data is to provide a portion of overall funding. But we can bring some ideas back to you in terms of a updated project request for ARPA funding, or as was alluded to before, you do have contingency funding within your budget. Of course, that requires a 2/3 vote, as would any allocation of the ARPA funding.
And I'll just add, so I was able to talk with my county conservationist. She did confirm that the DAC cap data is only for nitrates. It's privately held, and they will not share it. So they have never shared it. They will not share it. And she said that I should correct my statement that the UW Stevens Point said the 1,000 was their minimum recommendation, not their recommendation. So
with respect
based on the size of our county. So go ahead.
With respect to the deadline that was approved by HR Finance, I've been informed by Corporation Counsel it is April 1st is the next application deadline.
So maybe a better plan would be over the course of the next 6 months, develop some sort of a scalable approach to the project itself. As far as the infrastructure funding, was that primarily BIL money, like STP and TAP, or, because a lot of that stuff, I mean, that's going to be years in the future yet. 'Cause that goes through 26.
The 4-year highway projects that I was referring to?
Yeah, where was that directed towards?
The 4-year transportation plan was put together by the highway department with the understanding that the selection for the projects to receive that funding would be complete, I believe, by the end of this year. And we've already received word that I believe we've received a couple of the projects that were in the list. 2, for sure.
All right. Okay. Well, I think then with the discussion, scaling it to determine its competitiveness during the ARPA project cycle would be beneficial to staff and the success of the project. At least that's the consensus I'm getting from the committee right now. All right, staff, do you feel you have direction?
Yes.
Okay. Thank you. Moving on to 6A2, potential updates to General Code of Ordinances for Marathon County Chapter 17 zoning code in 2023. It is that time of the year. Go ahead, Chad.
Just one sec, let me get the slides up here. All right, so the intention of this is to kind of bring to the committee some potential updates we've been looking at for our Chapter 17 General Zoning Code and Chapter 22 Shoreline Zoning Code. So I'll kind of go over just a quick high level of the areas we're looking at and a little brief explanation as well. Starting with our Chapter 17 General Zoning Code, the first one being a zoning compliance review section for land divisions. And the purpose of this is generally, in the past, what has happened is our Chapter 18 land division ordinance used to have the power to require a CSM for neighbor-to-neighbor land transfers, which would require them to have a CSM.
I'm going to hit pause right now. And this is nothing against the rest of the members of the committee, but we got a lot of new ones here. So give them a little bit of background about, land division, how that process works. I mean, dividing land, of course, but give them a little bit more background there.
So with the land division area, it's essentially if a neighbor wants to move a property line, or if you want to divide a large parcel into smaller parcels, there's a various process you have to go through, which generally they go through our surveyor's office. They can get a certified survey map where they'd have a surveyor come out and mark out where the property lines are going to be, as well as in some cases you can do it by deed, which is just updating legal land description. A surveyor can also help with that. And with this change, in Chapter 18, we used to require a CSM for land divisions of 10 acres or less. With the change to Wisconsin Statute 23645, they took away that power to require a CSM, which essentially means we don't get to put it through our zoning review process. It can essentially get recorded, and then the change to the lot is accepted, meaning we can have non-conforming lots that don't abide by our zoning district standards created, therefore causing problems down the line, such as if somebody created a lot or wanted to move their property 5 feet, but that bumped them into a different zoning district, or the setback to a building wasn't correct, then the property line would be there and it wouldn't abide by that particular zoning district's standards, which when they bring to us these land divisions, it's oftentimes that's where we catch what you just all went through, the rezoning process. We catch, this no longer abides by rural residential. It needs to be bumped up into rural estate. Without this tool to us, we have no tool to essentially protect the integrity of our zoning districts for these smaller land divisions. This change would be essentially putting together something that would give us that tool to require a review of a land division. Not necessarily a CSM, but whether it be by deed, it would just be a tool for us to regulate those areas that our Chapter 18 no longer can. And if there's questions, I can move on, or if we want to talk about that one for a bit, that's fine as well.
Ask for questions for each topic and then just continue on.
Yep.
Any questions for Shad?
Chad or Garrett, I guess my question would be, how many times has this issue come up in the last year?
So after talking with the county surveyor, it's about 50% of the CSMs that we used to require that come in would fall under this category. So it's a large chunk of divisions that would come in that we would no longer have a review of. They could just get recorded at the Register of Deeds, and we wouldn't have access to inform them that they're creating a non-conforming lot. Yep.
In a non-zone town, would they still have to have a certified survey done if it's less than 10 acres?
So the actual zoning ordinance would only be for county-zone towns. Unfortunately, with the non-zone towns, the requirement to require them to get a CSM for those smaller land divisions, it wouldn't apply. The change to this would be, since it's Chapter 17, this would only apply to the county-zone towns.
Would you clarify that for me so that if someone says they want to create in a non-zone town, less, say, like 5 acres, would they have to get a certified survey map? That's survey done. That's my question.
Yep. So depending on the circumstance, they may be required, but if it's a neighbor-to-neighbor transfer, so adjoining property owners moving a property line and creating a lot smaller than, or 5 acres or smaller, they would not need to. But if they were creating a separate lot, so they went from one lot and they made 2 lots out of that, then they would.
Anything else for this one?
All right, then moving on to our conditional use permit and variance. The intent for this one is just to update the language to better follow state guidance and increase the clarity on the difference between the two. Our code right now actually has a area variance where you can pursue it as a conditional use, which is not in line with how state recommends that process to go. And essentially an area variance, for those of you that don't know, is essentially whether it's a size standard that a zoning district has, or a setback to a property line that a specific zoning district has, kind of moving that. So if the setback was 10 feet, an area variance might allow you to go to 6 feet or 3 feet. And so it's just to add some clarity to that section to our code.
Any questions?
All right. So moving on, density values for our zoning districts. State statute 66.1001 does indicate the counties regulate densities for our zoning districts. It's referenced multiple times in our code right now for things such as multifamily dwellings or conservation developments. Currently, we don't have a density, so if somebody came to us and said, we want to put a multifamily development in a certain zoning district, we would not have the authority to regulate how many units that would be. It was in the code in the past. I'm unaware of how it got removed, but it would be to put that back in the code to help us regulate those areas.
So Was it removed prior to the last revision, or how far along ago was it removed?
So I believe it was removed in the last revision, and from my understanding, two revisions ago? So 2 revisions ago. And from what my understanding is it was felt that the acreage amounts regulated how much you could build on a given parcel. Because a lot of our zoning districts, it's allowed one principal structure. However, in certain cases, those densities actually do help us regulate how much development can happen on a property. For instance, those multifamily dwellings.
So explain to me how you account for each dwelling. Like, what is the density measurement?
So it's essentially, it's a percentage, I believe, of, and I'd have to, it's generally per acre. So it's still a unit per acre. It would be, in fact, like, I don't have an exact one of what they were set before, but it would essentially be like 2.5 units per acre or something to that sense. So that would allow, instead of, if somebody wanted to put a multi-unit building in on one of these areas, we would be able to regulate, okay, well, the property is 2 acres, you can put this many units in, or you're going to go over the density. Otherwise, you could essentially have a big complex that
But isn't a lot of that, as far as structures per parcel, isn't a lot of that already a part of the code?
Yeah, so structures per parcel are part of the code. There's certain zoning districts that do allow for the multifamily dwellings. And in our code, it references that it must maintain, or it must not go over the density for said zoning district that it's allowed in. But there is no density in our code anymore specifically for that.
I've talked enough. Supervisor Trubinsky.
Thank you. I guess 2 questions. So this particular authority was removed 2 revisions ago. First question is, why was it taken out? Second question is, have we had any issues? Why come back and make a change? It sounds like we're making a change for the sake of making a change, not that we need to. It sounds like all we're doing is wordsmithing.
I'm going to interject in between just to clarify. We're not voting on this today. This is a what is the schedule here? This goes out, here it is. Yeah, this is a process. So asking questions today is great. Like, please ask them. But just, we're not voting any of this stuff today. So, sorry. Go ahead, Garrett.
So for your first question of why it was removed, is that correct? Okay, yeah. So specifically, I'm not sure the specific reason. My understanding from what I've heard talking from individuals was that they felt it was self-regulated by the acreage amounts per zoning standard. The reason why it is important to get back is it doesn't happen often that we would use those densities. But if for some reason a project were to come in, as far as a multifamily dwelling, and it's on a 2-acre lot, but it's zoned a specific way, they could essentially put as many units on that lot as possible, which could create conflicts with surrounding land uses. It would prevent us from, I guess, creating, conflicts, or resolving conflicts between other zoning districts, making sure that the integrity of each zoning district is maintained.
So when we talk about this looks like November is or December, I think we put this on the agenda again. I want a chart. I want you to explain that to me again.
Absolutely.
Okay.
Yep.
All right. Any questions for Shad? All right. Oh, Lori?
Yep.
Okay. Good? All right.
And moving on to the last thing for Chapter 17 would be just general code reference updates and clerical edits. There's been several state codes that have just been rewritten, so their reference is wrong in our code, so it'd just be updating those. Looking at kind of the timeline moving on, so October, initial outreach to towns. We'll prepare initial summary of the proposed updates. November 2022, initial discussion with ERC on proposed updates. That's where we'll get a little bit more specific in what those updates would be. Second round of outreach to towns in December. Evaluate and revise updates based on the input from the towns and ERC. In January, prepare a draft of all updates, present it to ERC, an open house for all towns, further discussion and revision based on the input. And then February to March, revised draft following input, adoption through ERC and county board. It's intended to be adopted, so it would be adopted before our busy season, essentially. If there's no questions, I can move on to our Chapter 22. These are just changes that the state have made. So in 2021, Act 105, they added an exempt structure to our shoreline setback, which is the distance you can build from the ordinary high water mark or for simple terms, just where the water meets the shoreline. And this would just be the addition of their language, which is fence structures, just adding that into our code so it's consistent with the state. As well as Wisconsin State Senate Bill 867, the viewing and access corridor standards. They just made a few updates on how we should regulate that as far as the size of it. Before it was 35%. Now it's a minimum of 35 feet, no matter your lot size. So it'll just be adding that into our code as well. And then including some adoptions of some flood studies that would better allow us to regulate our floodplains that we have in the county.
Can you go into some detail on the floodplain study?
Yep. So what happens is we are only allowed to regulate with flood studies that we've adopted. So in general, FEMA has floodplain maps that we use to regulate where the floodplain is, whether it be the floodway or the flood fringe, which come with different various regulations. So these flood studies, a lot of them are things that whether either the highway department had to do a flood study for a big project or a commercial building went in and they had to do a big flood study, and they actually studied these water bodies a little bit more than the data FEMA has for us. So we would have updated maps, essentially, with their data that we could use to regulate various projects around the river. It allows us to kind of hone in exactly where that floodplain lies to make sure that we're regulating it the proper way.
Any further questions? All right, seeing and hearing none. Couple of things to note in regards to, and a lot of this stuff is common sense, but it has been a point of contention for this group in the past. When these changes are being pursued, or when they're being developed, I should say, it's really important that as you get farther along in the process, you have some sort of summary document that has, the change itself, where it is in the code, the reason behind the change. That has produced a lot of discussion in the past for this group. So I know it's common sense, but just please be sure to do that so we don't get far enough in the process and then people have more questions and then it gets delayed. So that's the only comment I have for now. Anything else from the committee? If not, we'll definitely be seeing this in the future. All right, moving on to 6A3, user fee increase considerations, conservation planning and zoning. All right, and our administrator left. I had a question for him in regards to this, but Lori, you can start.
All right. Yeah, I think the last topic and this topic are really just meant to be an orientation and a start of the discussion because we'll be having it over the next couple months, but this is sort of just a heads up that we are doing some internal looking at our user fees, and we'll be bringing before you increased considerations for 2023. This is being done in part because we haven't looked at many of our zoning pouts or non-metallic fees in over 3 years. And these are also influenced by increase in personnel costs, increase in time we might be spending processing certain permits or performing certain functions. So anytime we are assessing a user fee, we're taking into consideration the time it takes to do that. We're not trying to make a profit or anything. We're just trying to recover our costs there. And then in certain cases, like the non-metallic mining, it is required by NR 135 that we recover our costs for administering that program through fees. So if the wage study and things like that increase our personnel costs, then we'll have to also consider if we need to increase some fee costs as well. Some other considerations when we do bring forth user fee increases is that we do do an analysis and compare to what other counties and municipalities are charging, just to make sure that we're not an anomaly in there, that we're being consistent, and again, that we're recouping costs associated with the average time on the effort. Again, we're not trying to get any more than what we need to pay for our time. So that's all I have. It's just a quick introduction that we will be considering that this winter as well. So.
Yeah, couple of things for this one for myself. So again, looking to what the committee has done in the past, maybe somebody's thinking this right now. Very first question that gets brought up with these fees is, what do other counties charge? It's the very first thing that gets brought up. I don't know if you have current data, but I know the last time that the fees were addressed, that data was presented.
Yes, and we have gathered that data. So
Good.
that will be coming forth in this presentation in the coming months.
Okay,
So,
okay.
yeah.
The other thing, it was more of a historical perspective that I wanted to have the administrator talk about, but understanding the way the fees interact with the levy, of course, where the more you charge for user fees, the less reliance the fees have on the levy, right? So there's these two different philosophies that if you charge more for user fees, there's less impact on the levy. It's more of a, you pay for what you get type of system. If you lean more on the levy, then there's more of this public benefit discussion where, there's a public benefit for everybody if you have, a zoning application thoroughly conducted or properly conducted, what have you. I cannot remember how the department has done in the past. I want to say it's like closer to 60-40 than 50-50.
It's about, we were looking through the old ERC minutes, and I believe it's about 55-45 for
55-45.
POUTs and zoning.
Okay.
Is about but we were looking through that too for the guidance.
Is it in favor of fees or the levy?
In favor of fees.
Okay. That sounds right. Okay.
So that was historical guidance on
Yep.
that. So.
Yep. So I know there's at least one county where their fees are 100% on the user, and they have some very expensive applications. So be thinking about chew on that when we start discussing this in the next couple months.
But
So.
the non-metallic, by law, there's certain things we have to charge 100% for.
Yes, in order to pay for the administration of the program. Yeah.
Correct.
Good point. Tony? Okay.
You just hit what I was going to ask.
Oh, okay. Okay. All right. Thank you.
Okay.
That concludes 6A 1 through 3. We move on to 7, policy issues discussion, potential committee determination. 7A, review of possible metallic mining resolution to be submitted to the state of Wisconsin. To introduce this topic, I'm going to give a little bit of a background. Chairman Gibbs received a resolution from one of the Marathon County Board Supervisors. I want to say it was sometime in August. And the way the process works is that the chair has a set amount of time to refer the item to a committee, and then the committee has the committee chair has a certain amount of time to put it on an agenda. So that is why this is in front of us today. In regards to the resolution itself, it was one proposed by Supervisor Mask. So Supervisor Mask, I'm going to give you an opportunity to address the committee here. So you got a microphone. Go ahead.
Thank you. My name is Jean Mask. I represent District 26 in the city of Mosinee, and I appreciate the resolution being put on the agenda and thank the people who worked hard to state the facts included in it. We are all acutely aware of how important water quality has become again recently. For more than 100 years, the upper Midwest was the nation's industrial center. Factories and paper mills left behind a legacy of toxic sites and polluted our fresh water sources. A lot has been done to clean up all of this, but we are not done. Our County Board Strategic Plan 6.3 reads, protect and enhance the quantity and quality of potable groundwater and potable surface water. Mining is a contradiction to this. One of our previous board members, John Durham, reread the ordinance recently and contacted me. He is in my district. His comment was, and I quote him, there is a serious flaw in our mining ordinance. It states that environmental remediation is the responsibility of the mining company or companies, but adds the phrase, when practicable, which could or would given out to the mining company when it comes to remediation. It's not too hard to foresee potential problems with that provision if mining actually takes place, unquote. This resolution states the facts, and we are asking the state to give us more control to protect our precious resources for clean water and clean land. If you read it, you can understand the depth of the seriousness here financially and environmentally. I respectfully request ERC forward this to the county board. Thank you.
So, like I said, I'm going to give everybody an opportunity to ask questions of Supervisor Mask for bringing the resolution in front of the committee today. Are there any questions in the meantime? Marilyn.
I have been involved with town government since 1961, a board of director with the Wisconsin Towns Association since 2003. I know what it takes to move something forward. You have to realize that when this was passed, it was passed in a Republican Assembly, it was passed in a Republican Senate, and signed by a Republican governor. We are thankful that Senator Jerry Petrosky at that time gave the counties a 6-month time where they could come up with something that would comply with what the state has. You have to realize that if you're going to put a bill forward, you have to have someone that's going to propose a bill, sign on to it, get out of committee, and be voted on. It's kind of hard to propose something where one party in control did it, and then now you want them to change it. That is very difficult to do. And if you want something further down in something else, you're going to have to work with the ones that are in control at the Assembly and in the Senate, and to be signed by the governor. If you go against them on something that they approved, they might not be as willing to do something for you as a grant or something in the future. It's very politicized right now, so you have to realize what the politics are going down in Madison. And if you want to change something that one party approved, it's going to be very difficult to get somebody to sign on to it, to get it out of committee, to get approved in the Assembly, to get it to the Senate, get out of committee, and approved, and then they both agree upon what they want to change, and then send it to the governor. So I think you need to realize that that's the process that has to go through to get something changed. And where you mentioned just something to be changed in Marathon County, it would have to be changed in every county. You just can't dictate that it's going to be just say changed in Marathon County. If you're going to change something like this, it has to be statewide. That's my comment. Thank you.
Thank you, Marilyn. We have to start somewhere. You know, if we start, maybe some other counties will start, and we need to do something to change this, and it might take a long time, but there's a lot of dedicated people behind this working toward trying to keep our waters safe. And there's a lot of the Ho-Chunk Nation, the Menominee Nation, and a lot of other people who are signing on to this, and I think that we have to start somewhere. I totally understand the process, and it stinks.
So, Supervisor Mask, Assembly Bill 499 was the bill that ultimately created Act 134. Do you know what the votes were in the Assembly and the Senate?
No.
So in the Senate, it passed 19-14, and the Assembly it passed 53 to 38 with 6 paired votes. The people that were in the legislature at that time remain largely unchanged today, and that also includes the party that is in the majority, as Marilyn pointed out as well. Have you done any sort of outreach to a member on that prevailing side in the legislature to gain their support behind this resolution?
Not yet.
That seems like a very important step if we want, if the ask is to have a change like this at the legislature. Because the risk is, and I'm sure you're aware of this, if this resolution goes to the state and the state sees it and the parties in power that be see it as well, we all know that there are a lot of things that as a county we don't have local control over. This might be a situation where we jeopardize the little local control that we already have. That is a very big concern that I have with this resolution. So to go back to your point, you've not reached out to any legislators in regards to this resolution?
Not yet.
Okay. No. My next question is in regards to, and again, this is a policy body. We develop policy. What is the policy question that is being addressed with this resolution?
I think that we need to have more control over our natural resources in this entire state. I think that we have to have more control in Marathon County, and I fought for this when we were in committee back in 2018 and voted to pass the ordinance that gave the mining companies their privileges to, I don't know what the word is I'm looking for, to assault our land. And I would like to start somewhere to get this going again. I don't know what the policy is. This is informative for now, and if I have to change it to be more informative or be more policy aligned, I will. But I really would appreciate it if it could be at least discussed at the county board level too.
I struggle with the resolution then in regards to the policy question that's being addressed. Because if it's a policy question as far as whether or not we protect our natural resources, that was decided when we passed the ordinance back in 2018. The policy question as far as the moratorium that was in place up until 2017, we don't have a say in that. The legislature does. Working with the legislature is the appropriate way to address that policy question. Would you agree?
Sure. But I voted no on the ordinance. I did not support the ordinance the way it was written.
The other thing I want to address with this, because we've sent resolutions to the state in the past in regards to certain topics that were being debated, especially during the budget season. The reason why we send those resolutions, at least it's my understanding, is because those are topics that are currently being debated in the legislature at that time. As far as metallic mining, the discussion at the state level, that is, I am not aware of any legislator that is taking that topic up. Are you, Supervisor Mask?
No, not yet. Like I said, nobody's been contacted yet.
Okay. I want to address a couple of points in the resolution as well. So, in regards to the first paragraph in the resolution that reads, whereas there are known metallic sulfide mineral deposits in Marathon County, hereinafter reef deposit, and a foreign-owned company is pursuing a license to drill exploration holes east of Wassa in the reef deposit with the intent to locate an open-pit metallic sulfide mine at the location. And wouldn't the intent behind the drilling be to determine whether or not a mine is even feasible instead of opening a mine itself?
They already have the right to do their drilling and to get the permit.
Well, they haven't received their permit from the Department of Natural Resources, and they haven't received their permit from Marathon County.
Not yet. But once they do, if they decide to mine.
But you're speculating there. Nothing's been determined.
You know,
see what I'm saying?
Okay. You can challenge me all you want, Jacob. However, this is still an informational thing. If I have to go back and start over again and go to a legislator and then bring it back, I will.
You can consider this feedback at the very least then.
Pardon me?
You can consider this feedback then at the very least.
Sure.
In addition to that, in regards to the exploratory drilling, which we both agree hasn't taken place yet because the permits have not been issued yet, one of the main problems that I have with the way that this is written is that it's very speculative, in that a lot of this stuff hasn't taken place yet. A lot of this stuff is very generic. It doesn't address a lot of actual facts itself. There are references to certain things that have taken place. I will give you that. But as far as whether or not this supposed mine that may or may not be opened will definitely pollute the environment, we don't know that. It's hard to make that determination when the permits haven't even been issued yet. Would you agree?
I agree with that, but I also think that and know that once this is determined, if they do start mining, we are going to experience pollution, period.
But you don't know that.
No, I don't. Not yet.
That's
but
all
I
speculation.
think it's still time to work on changing this if we can. I don't
Clarify
think there's any
that.
good time
Yep.
to do it.
Go ahead, sorry.
That's it. I just don't think there's any good time to do it. I was approached by a lot of people, and I think it's a good resolution. I think it's informative. If we have to go back and start over again, we'll start over again. But I think it's time to start addressing this and start looking at changing things at the state, because this is not going to go away. When the moratorium was lifted with Act 134, it just put everything wide open. Our ordinance just covers our butts, but it doesn't cover it completely. You know, it covers everything that the mining companies want to do, but when John Durham reread the ordinance and left that loophole, the ordinance left the loophole when practical for remediation. We know that metallic mines don't remediate well. I mean, they can leave so much stuff behind. I just want to see something done to where we don't have to have this in our state. We do not need this in our state.
I've got a number of people raising hands. I'm going to start with Supervisor Strafinski, then move on to Maryland, then Chair Gibbs. Did you have a comment? Okay. Tony, you're first.
Supervisor Mask, I guess the way I look at this is, and I remember what the water quality was in the Wausau area and presumably throughout the state of Wisconsin through the late 60s, early 70s, and we've made absolutely tremendous strides, unbelievable strides, and I'll give credit to all the state agencies and relative county agencies and whatnot for that. 1968, there is no way in the world I would have jumped in the Wisconsin River north of Wausau and done any swimming or any recreation. I now live on it. Okay, so I think we've come a tremendous ways in the last 30, 40 years. And from a policy perspective, we want to not only be, as it's on the wall, healthy and safe and but also prosperous. And I think where this resolution is headed is actually as a 100% roadblock to absolutely deny any possibility of any metallic mining whatsoever. Is that really the intent here?
No. And I remember when...
Explain why. It sure sounds like it.
Okay. The intent is to start another conversation, to get things moving, to either get another moratorium or to get more control on the county level or change our ordinance. I don't know what we do, but I am just tired of hearing about what could happen if we have metallic mining actually take place here.
So I did hear the word moratorium.
So hold on, Tony. Let's maintain decorum here. We're going to go to Maryland, then Chair Gibbs. If you have a follow-up, we'll get to you. Okay? Maryland, go ahead.
I have the problem where it just states within Marathon County, you know, in your, therefore be it resolved. And we have to realize that I've mentioned several times, the county cannot be more restrictive than what the state has. What the state has as restrictive, we can't be any stricter than that. So I still go back to say, you've got to have somebody lined up that's going to be willing to put their neck out, to sign on to a bill, and to get it passed. And so that we don't do any damage to get them ticked off and say, well, you do this, and you come and ask us for something, you want to do away with something that we proposed. Now you want us to propose something for you. It's a political game down there, very political on both sides. So be careful what you ask for and what you present to them. Thank you.
Thanks, Marilyn. I agree with you. I think maybe another process could be done here, another approach to make it more feasible. But I just still think it needs to be done. I don't know if we do it now or if we do it next year after the elections. But the feedback is good. It gives us something to think about.
Chair Gibbs.
Thank you, Mr. Chairman. I guess a couple of things that I'd like the committee to consider at least. You know, and Marilyn, you brought up some great points that be careful what you ask for if you don't have the legislators or legislature willing to take up the ask. The other thing is that right now, the way this resolution reads, it reads in contradiction to our own ordinance. So we would have to recognize in this resolution that it does contradict our current ordinance, or we'd have to repeal our current ordinance. If we repealed our current ordinance, we would have nothing that we would be able to do in any sulfide potential mine that may come about, if it comes about. And second, I think there has been proof that sulfide mining can be done responsibly when you take a look at what took place in the Flambeau mine. That's just my comments.
You have anything to add, Supervisor Mask? Okay. Supervisor Shafinsky, do you have a follow-up? No? All right. Supervisor Overbeck.
One of the things that concerns me is our water is our oil of the future. I mean, you look at all the areas in the United States or elsewhere that is dealing with water problems right now. Once that's gone, what do we have? You know, what is the value of that gold versus pollution within our water system? And we don't have water, which is the basis for life. So I guess that really concerns me that, you know, we talk about PFAS testing at $500 a test. We don't even have the ability to fund that type of testing. So how are we going to monitor this? I haven't heard real good answers from the DNR. We'll come out to the site. We'll look it over, you know, even during the drilling. Then you ask about the mining. But I think there's got to be a lot more answers given before we can say that this is a good thing for Wisconsin or even Marathon County. I really think the legislators, this is not a political issue. It's about a matter of life. Once that water is deteriorated to a condition that you can't use it. Look at what Wausau is going through with a new water facility that has to take out PFAS. Now we talk about tests. But what else is out there in the community? What's out there in the country that we have to deal with? And how will we know about it? And how will we pay for that contamination when that does happen? So I think politicians do have to take a look at this, and it can't just be a political argument. This is something about the future and the future of Wisconsin. We have a great resource in our water, and that can be sold, that can be marketed much more than even gold in the future. Mm-hmm. So I think we need to really look at that. So you know, the wording of that, it's got to go through different avenues. A resolution, often we send resolutions down to the state. They mean nothing. They get a little attention. But the real action is to start bringing this up in your communities in discussions and say, what are we going to do next? Because there's a lot of communities that are going to have to start to discuss that over the next year, next 5 years, next 10 years. So I think we really got to look at this and determine how we address our ordinances, how we address all industrial activities along waterways. So, thank you.
Supervisor Shafinsky said it. I remember my mother would not let my brother go in the house after he was water skiing in Lake Wausau. He smelled so bad, and we have gotten past that. We can't go backwards, and if we start polluting our water all over again, this is going to be worse than the paper mills. So if we can't get this resolution going now, we can start over, we can start addressing it from a different level, but we need to protect our water, and I don't want to see a mining company coming in and starting to pollute it if they do mine. I'm not going to wait to see if they do. I'm going to address it now. So this is starting a really good conversation. I think we need to keep it going. And I think it would be, well, maybe it could revise it and bring it back and send it to the county board, but it's starting a conversation, and this is good.
Supervisor Drabeck, but I want to add one point before Supervisor Drabeck starts. There's a document on the Wisconsin Department of Natural Resources website. It's how the Department of Natural Resources regulates metallic mining. And as far as regulating it says regulating a typical mining proposal. In Wisconsin, metallic mining activities are regulated under the Mining Law, Chapter 293 of statutes, which I believe our ordinance references. In addition, mining activities must be regulated by other laws that more specifically address each particular activity that may occur in association with mining. For example, any wastewater discharge from a proposed mine would be regulated by the same laws and rules that regulate wastewater discharges from all their municipal and industrial operations. Air emissions from mines are regulated by the state's air pollution control law, and mining waste disposal is regulated by the law that regulates all municipal and industrial solid waste disposal facilities. Most of these permits, approvals, and licenses are not specific to mining projects, but are common industrial activities and are regulated accordingly. A typical mining operation will likely need to obtain more than 10 separate permits, licenses, or approvals from the Department of Natural Resources. So it's not that it's the Wild West. The DNR has a say in the regulation of this practice. The other thing I'll add is that if you have any questions for the DNR, they did contact staff prior to today, and they said that you can reach out to them with any specific questions. Supervisor Drabeck.
Thank you, Mr. Chair. I was also listening to a speech from President Biden not that long ago. I can't remember how long ago exactly it was, where he had to do with the Defense Production Act, and where he made a directive on that, where to encourage mining and stuff like that, because people want green energy, and you either have to mine more to get the materials for that, or you don't have green energy. So I'm just wondering how this would get into this whole situation, whether we have any say on this whatsoever. Just a thought.
I would direct your comment to Supervisor Mask.
I'm not an expert, so I don't know.
Another couple of points that I had here in my review. In the second paragraph, in regards to giving background in the landscape and all the wonderful resources that we do have in this community and the connections that they have to other communities as well, I want to confirm that at the end of the day, you're assuming that if there's a properly regulated mining facility, if it were to be opened, right, because we don't even know if that's going to happen yet, because the drilling hasn't even taken place yet. But if it was properly regulated through all the laws and ordinances that we have in the state and the federal government that we have, and if it was properly monitored, you're still implying that pollution would take place.
Yes.
Then this is a discussion at the higher levels of government and not one to be had here. That's my point. I think it's the sixth paragraph that reads, whereas a mine located in an unconfined aquifer requires continuous pumping to prevent flooding the excavation, the resulting cone of depression drains down water from nearby wells otherwise needed for drinking water and agriculture. What's a cone of depression?
May I?
No.
Okay, I don't know.
I recognize you.
You recognize me, I
Yep.
don't know.
Okay. Supervisor Mask, who wrote this resolution?
There were several people.
Okay. I think it's number 7, paragraph 7, where actually, it might be 10, where it talks about, maybe it's a little bit faster. I think it's 11. Whereas potential economic losses to thousands of residential and business assets, including reduction in property values, loss of property taxes for county budgets, and loss of tourism revenue will linger for many years and negatively impact the area for greater than any short-term gain that might be had from such a venture. Would it be fair to say that if a mining operation or functioning and it did not pollute, that you'd also have to recognize the potential economic boost that it could have to the region if it were to operate effectively. Is that a fair statement?
No, I think that mining will pollute no matter what, period.
I think that in regards to the resolution, as I mentioned earlier, the Department of Natural Resources has to be addressed in regards to the regulation. As some others pointed out, in regards to the state as a whole, because this is a statewide effect and not just in Marathon County, you have to look at it as a statewide view. The biggest concern, one of the biggest concerns that I have, and I mentioned earlier, is that we have a very small window right now in regards to the monitoring of the operations. And we can't, as others have mentioned, we can't go more than what the state has. We can't preempt the state. That was a very popular discussion that we had back in 2018. I'm very concerned with what would happen if this message was sent to the state and we said that, well, we're not comfortable regulating this. We see it with CAFOs, right? There's the uniform regulation with CAFOs through the state. They'll do the same thing with this. That's the risk that is posed if we send something like this out there. I think that a better avenue, rather than coming to the county to send a resolution, which, as I mentioned earlier, we send resolutions when items are being currently debated at the state level. This isn't being debated. A better avenue is to address this with the state legislature, not here. I don't see an avenue where the county could have a potential swaying in what happens in the Capitol. I just don't. As others have noted as well. It's politics. It is what it is. We can't change that. Not until we get to elections, of course. Supervisor Mask. No, I'm not recognizing you. Supervisor Mask, go ahead. Sir, I will hold you out of order. Supervisor Mask, go ahead.
I forgot what I was going to say.
Take a second.
No, this is all good feedback. I still think we need to address it, so this is a good conversation. I'm no expert. I wasn't an expert in 2018 when we were having this debate and we had so much public comment against it. I still think that this needs to be addressed. If we take a different avenue, it still needs to be addressed. Our water is precious. And just like Supervisor Overbeck said, if we don't take care of it, we have to take care of it. We have to find a way to make sure that nobody is going to start polluting it again. We have enough pollution that we have to deal with manure, with even the industry is still doing it to a certain degree. PFAS. I mean, what else do we have to put up with? I can't boil my water every time I want to make a cup of coffee. There aren't enough filters in the world that are going to clean it. But if you start putting these dangerous chemicals into the ground and potentially pollute it, that could be ruined for 100 years. So I really think that we need to have a conversation, which we're having, and we'll take it to the legislature. We'll find a different way to approach it. But this state needs to get its butt going and fix this. And I don't care if it's Republicans or Democrats. This is not a Republican or Democrat thing. This is a human rights thing. This is our environment. Look at Lake Mead. Would you want to live there and not have water? These people don't have any other sources of water. They're going to start moving here. They're going to start moving out of the hurricane centers. They're going to start moving from all the forest fires. And the Midwest is going to start getting blasted. We have the cleanest big lakes in the world right here. And we don't need to pollute anymore. And we are going to be losing our water. Maybe not in our lifetime, but we need to start doing something, and this is a start.
Supervisor Sherfinsky?
I think the other thing, though, that this is a policy question, and I agree. I think it's excellent that you bring this up and that we start having these discussions, and you make some very good points. But I think the history is also over the last 50 years, actually over the last 100 years, we went through a period of development where we didn't understand what we were doing, what some of the consequences were. We began to understand 40, 50, 60 years ago. Our history, recent history shows that we can have solid economic prospects, development, and opportunity, and also be undeniably the cleanest, most environmentally friendly country in our area on the planet, much more so than many other areas where things are unregulated. So the policy questions here become one of environment, but it also becomes one of economic opportunity and also maintaining our population and encouraging people to stay, encouraging our young people to stay, and perhaps even encouraging people to move back into the area. Because otherwise we're going to end up being depopulated, we're going to start losing industry, and we're going to start having a declining prosperity in Marathon County if we don't have good jobs and good opportunity for our citizens. So I think we need to manage both of those expectations. And you're coming from one perspective, perhaps I'm coming from another side of it, but I think we need to look at both sides of that equation.
Any comments, Supervisor Mask?
Only that mining is short-term, so any jobs related to it will be short-term. It's not a long-term thing when you're talking about the economy and jobs.
So to get back to earlier discussion, in regards to this resolution, then what is the ask behind it? And what is the ask?
To allow our counties to have more control over the mines. To ask the state actually to put a moratorium back on metallic mining would be my ask. This is opening up a conversation. This can be revised.
Yep, I apologize. I meant, what is the ask as far as what do we do with this?
Well, I guess we're going to go back and rewrite it and talk to somebody in the legislature and see what we can get going there, because I know it's not going to pass here, and I can understand why.
Anything else from the committee? Comments? A motion could be made. I'll be transparent here. A motion can be made, so it's up to the committee. Any action? Any final comments, questions? Supervisor Overbeck?
I guess I'd ask thank you, but I think I'd ask what is the purpose of the Environmental Resources Committee? I mean, we're not the Metallic Mining Committee. We are there we've been going through a lot of things to protect our water. And I think we really got to consider we talk about economy and what happens if our water source goes bad. I mean, our county affects other counties. That water moves throughout the state of Wisconsin. The ask should be that the state of Wisconsin repeal what they actually did. That's the ask, because we can't say we're going to be clean water, and Lincoln County does not accept that. Water flows, and what we affect other states also. So I mean, it's a bigger picture here. And I think the economics of Wisconsin is water. I don't think it's metallic mining. I think you're going to see people move. As you stated, people are moving back to environmentally sensitive areas that are protecting the resources, and that's what our asset is. I think we really got to evaluate this and how it affects the other parts of the state, and maybe we got to ask other counties that, it all starts somewhere, and other counties may have to jump on board with this. Because I think what we've seen now with everything that's going on, forest fires, hurricanes, whatever, these areas are becoming where people have to move out of these areas to survive. And that's the next, if you look at the global economy, that's what you're going to see, is people moving out of areas that are no longer viable for life. And it's going to be the rising seas, whatever, temperatures, whatever. You're going to see that. And it's going to happen throughout. So I think as the role of the Environmental Resources Committee, I think we have the oversight to start looking at these things and how we protect our environment around us.
Marilyn, go ahead.
I think where you need to start is you need to talk to the legislature. You need to get some senators and assembly people that are willing to make a change. That's where it has to start. you get enough people involved that want to make a change, you need to talk to the ones in Madison, like Jake said, that for them to propose some type of legislation. That's where it needs to start. Not just here, because this resolution really can't affect that much. You need to go to the legislature, get some senator or assembly person to say, yes, we want to make a change, and let them get it out of committee and vote on it. And I think that's going to be a hard sell with manufacturing and commerce, as strong as they are in the state of Wisconsin.
Okay. Any other comments from committee, questions? All right. Seeing none, we'll move on to item 7B, motion to go into closed session. I'd ask that somebody please make that motion. After the motion is made, we'll take a 5-minute break. Or, sorry, actually, no. Let's take a 5-minute break before the motion is made. We'll reconvene at 5:11.